Anisha, who's tracking court for us. Anisha, this is a two-day status quo. Do explain to us yet again how is this viewed as a win for the Muslim side?
Well, the Muslim side has been, since this morning when the matter was mentioned before the Supreme Court, they have been arguing that they were not given adequate time to go before the High Court and file an appeal. They've also been saying that this is an invasive survey that is going on. In fact, Senior Advocate Huzaifa Ahmadi started his arguments by saying that they've been given reliable information that the ASI is digging right next to the Western Wall. In addition, the Muslim side, of course, has also been arguing that this kind of a survey order could not have been passed by the district court in the first place, that they have the district judge's order is legally incorrect and therefore should have been stayed. Now, with the Supreme Court issuing a status quo order, even though it is for just 2 days, the Muslim side now gets a chance to go before the High Court. They get another chance to argue their case before the High Court, because remember, the district court's order that was passed on Friday at 4:30 p.m. has said that the advocate commission survey, which is under an order of stay by the Supreme Court, and I understand this is a very complicated issue because there have been multiple rounds of litigation and multiple orders are involved. So just for the clarification of our viewers, I'm again explaining this. The Muslim side had argued that the Supreme Court had last year issued a stay on the survey or the ASI survey or any further proceedings with regard to that sealed portion and sealed that portion which is known as the Wazu Khana by the Muslim side and is being claimed as a Shivling by the Hindu side. Now, the Muslim side had said that when there is a stay order on any kind of survey, then how can the district court then order another survey by the ASI on the general premises, even if it is outside of that sealed particular area? The district court in his order passed on Friday had said that this is a distinct area, that the sealed area is not being touched, and therefore I am ordering an ASI survey because the final decision in the suit of whether the Hindu devotees can be allowed to enter the temple, what the structure of the area actually is, and what is actually existing underneath the walls and underneath the floors can only be decided if there is scientific evidence, and the ASI is the only agency which can bring this kind of scientific evidence before the courts. That was the grounds, that was the reasoning which the district court had given in its order passed on Friday, that we can't go ahead with hearing the matter or deciding the matter till there is some sort of a scientific evidence available. The Muslim side, on the other hand, is saying that the scientific evidence is not something of a priority at this stage, that the court should have first heard the issue of maintainability, the court should have first heard the issue of whether the Hindu devotees can raise these kind of contentions at all, whether there is a case to be heard at all, and if there is a case to be heard at all, how will that case proceed? That should be decided, and after that there could have been an ASI survey or whatever other survey that is going to be ordered. According to the Muslim side, this kind of an order was passed and I'm quoting Senior Advocate Huzaifa Ahmadi here, this kind of an order was passed in a tearing hurry, and that is the objection that the Muslim side has raised, that A, this order was passed in a hurry, B, legally this order could not have been passed, C, that this kind of a survey will create communal tension, D, that this kind of a, if there is any excavation of the area, it could potentially damage the medieval era buildings that have stood since the 1600s. And therefore, the Muslim side has been arguing against the ASI survey. Now, with 2 days of breathing room, as the Chief Justice has labelled this, 2 days of breathing room has been given to the Muslim side. They can now go to the Allahabad High Court. Additionally, the Supreme Court has also requested the Registrar General of the Allahabad High Court to make sure that this matter is listed before a bench on Wednesday, which means that the Muslim side petitioners will now be running off to Allahabad High Court, will be filing a petition as soon as possible to make sure that on Wednesday, when the High Court, that they have something to present before the High Court so that the matter can be listed on Wednesday. This is going to be a very, very hard-fought argument. This is going to be a very hard-fought case, Nabila, because on one side, as the Hindu petitioners claim, that they have a right to worship and therefore they have a right to enter where the temple exists. The Muslim side, of course, saying that you are being allowed to enter the premises where the Sringar Gauri temple existed. You cannot lay claim to the entire premises because for the last 600 years, this has been a mosque. And as of 1947, which is when India gained independence, which is what the cutoff date for the 1991 Places of Worship Act is, according to that date, there was a Muslim mosque that has existed for about 500 years, and therefore the temple and the mosque both need to exist side by side. You cannot claim the mosque area for the temple. The Hindu petitioners, of course, saying that this is not a legitimate mosque. It was built after demolishing an ancient temple, and therefore that temple should be restored. The Supreme Court will have to look into a lot of nuances. The courts will have to look into a lot of nuances, religious, political. This is a powder keg that is being opened, but for now, all action in the Allahabad High Court now on Wednesday.